Welcome to the case on Lucknow Development Authority vs. M.K. Gupta, 1994, a landmark judgment in Indian consumer law. This case falls under the Consumer Protection Act, 1986, which was enacted to safeguard consumers from unfair trade practices and service deficiencies. But can a government authority be held accountable under consumer law? This case provides a clear answer. M.K. Gupta, an ordinary citizen, booked a house with the Lucknow Development Authority, LDA, a government body responsible for providing housing services. Many consumers in India face delays, substandard services, and negligence from both private companies and government agencies. He paid the full amount, expecting timely possession of a well-constructed house. However, months passed with no progress. When he finally received possession, he was shocked. The house was poorly built, far from the promised quality. Cracks in the walls, leaking ceilings, and incomplete facilities made it unfit for living. Feeling cheated and frustrated, Gupta decided to take legal action. He approached the consumer court, claiming that LDA had failed in its duty to provide proper service. The major legal question in this case was, does the Consumer Protection Act, 1986, apply to government agencies like LDA? But the big question was, could a government agency be sued under consumer law? Can a consumer challenge a public authority for poor service just like a private business? According to the Act, a consumer is any person who avails goods or services for consideration. It also states that any service provider, public or private, is responsible for ensuring quality service. If they fail to meet their obligations, they can be held accountable for deficiency in service. The case first reached the National Consumer Disputes Redressal Commission, NCDRC. Later, it went to the Supreme Court of India, where a landmark ruling was made. The Supreme Court ruled in favor of M.K. Gupta. It stated that government agencies providing paid services fall under the Consumer Protection Act. The court held that just because an organization is public does not mean it can avoid liability. If a government body charges money for a service, it is accountable for its quality. The Supreme Court found LDA guilty of unfair trade practices and deficiency in service. It ordered compensation to M.K. Gupta for the mental distress, financial loss, and inconvenience he suffered. This ruling reinforced the idea that consumers, whether dealing with private companies or government entities, have the right to seek justice. This case was a turning point for consumer protection in India. It established that government service providers cannot take consumers for granted. Whether it is a housing board, municipal corporation, or any other authority, they must deliver what they promise. The ruling strengthened the Consumer Protection Act of 1986, ensuring that service providers, including government agencies, are accountable for delays, poor service, and inefficiencies. This judgment empowered consumers, giving them the confidence to demand fair treatment. As a consumer, you have the right to demand quality services, whether from a private company or a government agency. If you face delays, poor service, or broken promises, you can take legal action under the Consumer Protection Act. Stay informed, know your rights, and never hesitate to fight for fair treatment. Thank you for watching.